So hello and welcome to today's HR Huddle on it's an employment law session with Keeley Baigent of KSAB Law. So today we're going to focus on all the legislative and case law changes that we might have missed in 2020 when we've been busy with COVID-19. So if you have any questions, feel free to put them in the chat box on the bottom right, but we're aiming for the session to be approximately an hour. If we do run over and you need to leave, don't worry, everything will be recorded and we'll send it to you along with Keeley's slides. So thank you for joining us again, Keeley, and for your ongoing support and advice. And I will pass over to you if that's okay.
Yeah, that's brilliant. So hello everybody and welcome to today's HR Huddle. So as Eloise has said, it's an employment law update. I'm going to be talking to you about what I believe to be many of the notable case law developments and legislative developments that have come in this year that we may have missed because it was grappling with the implications of COVID-19 and all that brought into our workplaces. So I'm going to deal with case law developments in a number of areas, including unfair dismissal, constructive unfair dismissal, discrimination, and vicarious liability. And then I'll finish off with 3 legislative developments that you may or may not be aware of. So I'm going to share my slides with you. Please feel free to ask any questions as we go along by raising them in the chat box, or alternatively we can deal with them at the end. And as Eloise said, I'll be sending my slides over to her so she can forward them to you at the end of the presentation. So the first, hold on a moment. Hold on. There we are. So the first area we're going to look at then is unfair dismissal. And in particular, the question that arose in the case of Ty, Tarian and Christie, which was it fair to dismiss an employee in reliance on the evidence of an anonymous witness? The background to this case is that, as we all are aware, a dismissal for gross misconduct is fair if in the circumstances the employer acted reasonably in treating the conduct as sufficient to dismiss for. There's usually this 3-stage test that we're aware of under the case of VHS and Birchall, which is applicable to misconduct cases that we need to consider in determining the fairness of the dismissal. And the first element of the test is, does the employer believe that the employee is guilty? Secondly, does the employer have reasonable grounds for holding that belief? And thirdly then, does the has the employer conducted a sufficiently and reasonable investigation to hold that belief? So it's really important that we look at that 3-stage test in a misconduct case to make sure that they or each element is satisfied. And then more latterly, at the end, we just need to make sure that taking a reasonable view, would the dismissal fall within the range of reasonable responses of a reasonable employer in the circumstances? So it's stepping back and it's saying, would an employer have dismissed for this reason in these circumstances? And that's the question the tribunal will ask in the tribunal. At a hearing. So this case then, the one that we're going to look at is Ty, Tarian and Christie. The facts of the case are that the claimant was summarily dismissed for making homophobic remarks to a tenant of one of the respondent's properties. The respondent relied on the evidence given by the tenant, who had been interviewed twice at the investigation stage, but had requested anonymity. So their name was never put forward as the person who made the statement. The managers deciding the dismissal and subsequent appeal did not interview the tenant themselves, so they relied on the written statement and they didn't consider any other evidence. So what do you think? Do you think that the claimant succeeded in their claim for unfair dismissal in reliance of insufficient investigation and relying just simply on an anonymised statement to dismiss them? Or do you think the respondent succeeded in unfair dismissal? Well, the decision of the Employment Tribunal was that they thought the claimant had been unfairly dismissed. They felt that it wasn't within the range of reasonable responses of a reasonable employer to have dismissed in relying just on the anonymised witness statement, and the employer should have gone further to ensure that the claimant had had a fair hearing in the circumstances. So the respondent appealed. And what do you think? Do you think the EAT agreed with the Employment Tribunal, or do you think it sided with the respondent? Well, it actually decided with the respondent. So it went against the Employment Tribunal's decision. And what it said was the Employment Tribunal had actually failed to show any good reason for finding that the respondent could not have reasonably accepted the evidence of an anonymous witness as truthful. And in this case, there was no need for the employer to have gone further and actually tried to find other evidence to support the anonymous witness's account. Because there was nothing that the claimant had put forward to say, well, actually, the tenant was lying. So it never gave the employer any reason to then question the truthfulness of the account. I mean, it's quite a helpful one for employers, this case, because in these circumstances, the EAT decided, as we've said, that there was no need for the employer to go any further than simply get or rely on the anonymised witness statement. But please take caution, because if the account had been contested as untruthful, then I think the employer in the circumstances would have been obliged to look further. And in any case, I think an employer must do as much as it can to ensure that the claimant has or the employee has a fair hearing. Looking then at the next case in the area of constructive unfair dismissal. So the relevant background in this case is that an employee is able to bring a claim for ordinary constructive unfair dismissal if they have at least 2 years service and they resign as a consequence of a fundamental breach of contract by the employer. Now, that fundamental breach of contract by the employer can be a breach of the implied term of trust and confidence. So in every employment contract, there is a term that is implied that an employer must not act in a way that undermines the trust and confidence in the employment relationship. And if that trust and confidence is undermined, then it does amount to a fundamental or very serious breach of contract, entitling the employee to resign and bring a claim for constructive unfair dismissal. The case we're going to have a look at in this area today is the case of Hobbs and Avon Care Homes Limited. The facts of the case are that Ms. Hobbs, who is the claimant, was employed as a secretary at the care provider Avon Homes Limited, and she assisted Miss Beeler, who was the owner and managing director of the company, and then the regional manager, Mrs. Ray, with recruitment. So following a referral from an executive search firm, the job candidate, Mrs. Mills, was interviewed for the position of home manager. She was interviewed by Mrs. Ray with the claimant present to take notes. The owner, Miss Beeler, was on holiday, so she wasn't involved in the initial interview. Mrs. Ray was impressed with how Mrs. Mills performed in the interview, but the claimant and Mrs. Ray were both concerned about how Miss Beeler, the owner, would react to Mrs. Mills being black. because of Mrs. Barley's known prejudices about Black people working in the care sector. The claimant was worried about how she would inform Miss Beeler about the candidate's ethnicity. Miss Ray wasn't able to speak with Miss Beeler, so it fell to the claimant to explain to Miss Beeler when she returned from holiday about Mrs. Mills. And she said the following: I know you think that your residents have in the past not liked being cared for by Black people, and I know that you are reluctant to employ Mrs. Mills, and it has affected your decision, but I'm really struggling with this decision. I know you are not racist, but this opinion by the residents is unfortunately influencing you. Now, Miss Beeler went ahead and told the claimant that she didn't want to employ Mrs. Mills because she was Black. So the claimant said, well, that's illegal and unlawful, and I'm not agreeing with what you're proposing. Notes from this conversation were actually considered by the tribunal, and they indicated that Miss Beeler had expressed the view that having Black people in charge of a care home is not going to work, and that she would interview Mrs. Mills and then say she didn't like her. So the claimant was then instructed to set up an interview with Mrs. Mills, despite Miss Beeler's predetermined decision then not to offer her the role. The claimant realised she couldn't work for the care home anymore, and so she resigned. And she brought a claim for constructive unfair dismissal before she raised any kind of grievance. She said, I'm unable to continue working for a company that has illegal working practices with regard to racial and colour prejudice held by the managing director. I am unwilling to lie to recruitment agencies, as this makes me complicit with these illegal practices. So she pursues her claim in the Employment Tribunal for constructive unfair dismissal. The care home actually say that what she was saying was a lie, but obviously there was the note to support, albeit it was made by the claimant to support her account, the contemporaneous note. The other, Mrs. Ray, didn't give evidence. So in effect, it was the care home managers, the care home owner's account against the claimant's account as to what happened. The tribunal believed the claimant, and it did uphold her claim for constructive unfair dismissal, unsurprisingly. What I think is important for us to take into account is that the fact that the claimant didn't raise a grievance before she resigned. And the tribunal's view in this situation was that the trust and confidence in the relationship had been so utterly undermined by the owner's instruction about not going to give Mrs. Mills a job because of the colour of her skin, that there was no obligation for the claimant to raise a grievance before resigning in the circumstances. So I think the thing that we can take away from this is that if an employee can show that trust and confidence in the employment relationship has been undermined by the employer to a considerable extent, then the claimant will not be obliged to bring a grievance or raise a grievance before they pursue a claim in the employment tribunal. And in this case, it had no effect on the level of compensation either. Usually if an employee fails to raise a grievance before pursuing a claim in the employment tribunal, then it will have implications on the level of compensation awarded to an employee. But in this case, because of the seriousness of the undermining of the trust and confidence, no percentage reduction was made. Now, this is quite an interesting case in the area of age discrimination, and one really that I think is going to be more applicable to us potentially. The case is that of Mr. Levy against McHale Legal, and it concerns direct age discrimination. So direct age discrimination occurs where an individual is treated less favourably because of their age. It's important to have a comparator in a direct discrimination case. So it might be that the claimant is able to point to a real comparator of a different age, or alternatively, the claimant needs to point to a hypothetical comparator of a different age and argue that if that hypothetical comparator existed, they would be treated more favourably than them because of their age. So, as I say, in direct discrimination cases, claimants will always need to point to an actual or a hypothetical comparator to show that they have received less favourable treatment because of the protected characteristic, and in this case, age. In direct age discrimination, the treatment can actually be justified. It's the only protected characteristic in respect of direct discrimination that can be justified. So, as I say, the treatment can be justified if the employer can show that the treatment was proportionate to achieve a legitimate aim. So the facts then of this case are that McHale Legal were recruiting for a commercial property solicitor, and Mr. Levy applied for this post, and he was the only applicant. At the time of his interview, Mr. Levy was 57 years of age. He had been practicing as a solicitor since 1985. The job he applied for sought for somebody with at least 5 years post-qualification experience, and that was stated on the advert. A Mrs. S from McHale Legal needed to hire somebody very soon in the post because a senior associate was leaving the firm and work was piling up as new instructions were coming on, and she relayed this to Mr. Levy at interview. Miss S asked Levy what salary he was looking for. As the role was based in Manchester, Levy was aware that the salary would be less than the £60,000 he would be expected to receive in London for the post, or for a similar post. And so what he did was suggested that the salary of the departing associate be the starting point for discussion. The associate was actually paid £42,000 per annum, but Levy suggested that he would be able to work, certainly for the initial 3 months, first 3 months, for a sum of £50,000. And he even offered to work on a self-employed basis, consultancy basis, if that would assist the firm, if they were looking for more flexibility. Levy then went away, left it with the firm. Miss S met with the other department heads, and notes of this meeting suggested that the claimant was actually asking for a salary of £50,000 to £60,000, which obviously overstated what Mr. Levy had said at interview. The note also suggested that Levy was expensive and he doesn't cover all of our needs, was what was stated on the note. Levy then received an email which stated that his application had been unsuccessful, and it said, "I regret to inform you that at this stage we would not require your services as we have decided to go for a 3 to 5 year post-qualification experience candidate or solicitor who we can train or mould to our specific requirements. In the meantime, the work would be covered by Miss S, a paralegal, and another paralegal who was actually an Israeli lawyer who had yet to qualify." So Levy then brings a claim for age discrimination. In response to that claim, McHale Legal said the advert for a 5+ PQE solicitor was to test the market and enable it to decide whether to go ahead with provisional plans to recruit somebody with this level of experience. It said its decision not to recruit Mr. Levy was based on the fact that a senior solicitor would command a higher salary consistent then with its note that the claimant was expensive, it decided it no longer required a senior hire, that it intended to monitor the situation and then would consider a more junior hire. So what do you think? Do you think Levy succeeded in his claim for direct age discrimination? Well, the tribunal considered all the arguments and it decided that Mr. Levy's age either contributed to or was the principal reason for McHale Legal's decision not to appoint him as a commercial property solicitor. In its judgment, it says, the notes from the management meeting gave no indication that the claimant's application was given any real attention. Rather, the note made by Miss S said simply that he was expensive and doesn't cover all of our needs. This suggested a cursory knee-jerk reaction to the salary expectations with which Miss S had incorrectly told her colleagues to be £50,000 to £60,000, when the reality was that the claimant was willing to accept around £50,000. The tribunal was very damning in its judgment. It referred to the firm's lack of equal opportunities training. Although it referred to the firm having an equal opportunities policy, it stated that it didn't practice that policy and it didn't implement that policy. It criticised the firm's approach in dealing with the litigation because the firm had actually told Mr. Levy that they would report him to the Solicitors Regulatory Authority if he continued with his claim, and they said it was bullying. And they were very, very harsh on the firm generally. And I think that, what the tribunal indicated, that they thought the real reason for the for not offering Levy the role was his age. They indicated that potentially the aim of appointing a solicitor that matched the commercial needs of the firm could have been a legitimate aim, but by not offering Levy the role, that was not a proportionate means of achieving that aim. And in fact, what the firm could have done and should have done if expense was an issue was go back to Mr. Levy and say, we need to try and discuss with you the salary sum, which he had indicated he was happy to do. So by the firm basically turning away from him and not engaging in those negotiations, it had failed to justify the action of not offering Levy the job. I think it's an important one for employers, this case, because what we learned from it is that employers really need to assess at the very beginning of a recruitment exercise exactly what their ideal candidate is or post holder is, in terms of assessing the probable market cost of that appointment. Do they need somebody as experienced, or do they need somebody less experienced who will carry potentially a lesser salary cost? If then they determine the suitable or ideal job holder or candidate, that needs to be reflected in the advert and the recruitment exercise. And if there is a change of mindset on appointment from what's indicated in the initial advert, then that really needs to be justified by reference to obviously a non-discriminatory and a reasonable reason. Okay, so we're going to move on then and have a look at our next area, which is discrimination on the ground of or because of religion or religious belief. And this particular case is the case of Higgs and Farmers School. And you may well have seen this one in the press recently. So the background to the case is that, as we know, religion or religious belief or similar belief is a protected characteristic under the Equality Act. The protected characteristic is defined as Religion means any religion and a reference to religion, and includes a reference to a lack of religion, so atheism, for example. Belief means any religious or philosophical belief, and a reference to belief includes reference to a lack of belief as well. In the case of Granger, which we looked at a few years ago, it was decided in 2010, the EAT actually gave us quite a helpful guidance in determining what beliefs could be protected under this category. It said that what was required for a belief to be protected was that it must be a belief that is genuinely held. It must not be an opinion or a viewpoint. It must be a belief as to a weighty and substantial aspect of human life or behaviour. It must attain a certain level of cogency, seriousness, cohesion, and importance, and it must be worthy of respect in a democratic society, not be incompatible with human dignity, and not conflict with fundamental human rights of others. Looking then at the categories of discrimination, direct religion or belief discrimination occurs where an individual is treated less favourably than another because of their religion or belief. So as we've seen, what the complainant again has to do is point to a real or a hypothetical comparator of a different religion or belief, and say these people are being treated more favourably than me, and therefore my treatment is less favourable treatment on ground of my religion or my belief. Religion or belief harassment occurs where an individual experiences unwanted conduct which is related to religion or belief, and that conduct has the purpose or effect of creating an intimidating, hostile, degrading, or humiliating environment for them, or violating their dignity. So the facts then of this case are that Mrs. Higgs is a Christian, and she was employed as a pastoral administrator and work experience manager by the school. The school's head teacher received an email from someone outside the school making a complaint about Mrs. Higgs. The complaint related to a Facebook post which the complainant considered demonstrated that Mrs. Higgs held homophobic and prejudiced views against the lesbian, gay, bisexual or transgender community. The relevant post was a reposting of a piece written by another person to which she had added, "Please read this, they are brainwashing our children," and a request to sign a petition. The post related to the teaching in schools of same-sex relationships, same-sex marriage, and gender being a matter of choice. The school's teacher replied by asking the complainant to send him any other screenshots of any similarly offensive posts. And as a result, the complainant did just that. And he sent Mrs. Higgs's reposting of an article written by a third party, which referred to gender fluidity as a perverted vision, and that the LGBT crowd, with the assistance of the progressive school systems, are destroying the minds of normal children by promoting mental illness. And it went on. So, following an investigation and a disciplinary hearing, Mrs. Higgs was dismissed for gross misconduct, for breaching the school's conduct policy, including in relation to discrimination and serious inappropriate use of social media. Her internal appeal was unsuccessful. So, what did she do? Well, she brought a claim. She brought a claim that she had been directly discriminated against and harassed on the ground of her religion or belief. And she also claimed that her human rights, and in particular a right to a private life, had been breached. That's under the European Convention of Human Rights. So the first hurdle she has to jump across in bringing her claim is to show that her beliefs are protected. They are protected under the Equality Act. So she listed her beliefs as those that are detailed on the slide. So they included a lack of belief in gender fluidity, a lack of belief that someone could change their biological sex or gender, belief in marriage as a divinely instituted lifelong union between one man and one woman, a lack of belief in same-sex marriage, opposition to sex and relationship education for primary school children, and a literal belief in the Bible, i.e. God created man in his own image. In the image of God, he created him. Male and female, he created him. So in looking at these beliefs, the school accepted that some of these did amount to religious or beliefs that, religion or religious beliefs, that were due protection under the Equality Act. The ones that they questioned that were due, that could be protected included lack of belief in gender fluidity and lack of belief that someone could change their sex, because they said under the Granger case, surely those beliefs are incompatible with human dignity and conflicted with the fundamental rights of others. Yeah, so the tribunal then has to decide whether or not those beliefs are protected. What do we think? Well, the tribunal went on to consider the matter and they decided that all of those beliefs were protected. And they said that although Mrs. Higgs' beliefs that sex and gender are set at birth may be upsetting to some people, these beliefs were in any case protected under the Equality Act. So these, they say, are protected beliefs and worthy of protection, which I find a bit astonishing from that. But anyway, so we then go back to the tribunal. So beliefs are covered. So she then says, well, because of these beliefs, I believe that I have been discriminated against directly, and I also believe that I have been harassed because of holding these beliefs. So what do we think? In relation then to direct discrimination and harassment, actually, the tribunal said that although these beliefs are protected, we do not believe that Mrs. Higgs' dismissal and the disciplinary action taken against her were because of or on the ground of her holding these beliefs. So they said that she hadn't experienced, therefore, any direct discrimination or any harassment. And I'll go through the reasons with you. So the tribunal held that the action taken by the school against Mrs. Higgs was not because of her protected beliefs, but because, further to her Facebook posts, she would reasonably be perceived by any reader as holding unacceptable views in relation to gay and transgender people. So the tribunal considered that Mrs. Higgs had essentially been dismissed because of the Facebook posts might reasonably lead somebody to conclude that she was homophobic or transphobic or both. And the school had considered that this had the potential to negatively impact on various groups of people, including pupils, parents, staff, and the wider community. The tribunal took into account the fact that Mrs. Higgs made it very clear that she is not going to desist in making these posts on her Facebook page and will continue, she said, to make those posts. In relation to the harassment claim, not only did the tribunal decide that the harassment was related, or they decided the harassment wasn't related to her beliefs, it also said that the disciplinary action did not, in the circumstances, create an intimidatory or hostile, degrading, offensive environment for her, so it didn't satisfy the definition of harassment. In relation to the right to a private life, Mrs. Higgs said, obviously, that her posts were on a Facebook page that was private, and therefore shouldn't she be allowed to post her beliefs on the Facebook page? She's got a right to a private life. And the tribunal said, no, we don't believe that that right has been breached, because although it's posted on a private page, a number of the parents access that page of the school children, and also she had a lot of people on her, she had a lot of friends on her Facebook account. And they also made the point that somebody could have taken a screenshot of the posts and circulated it to further viewers. So Mrs. Higgs then says that she will appeal this decision. She states, I strongly maintain that I lost my job because of my Christian beliefs, beliefs which our society does not appear to tolerate or even understand anymore. And she made some further comments as well. So we await the appeal outcome. It's an interesting one, because the school actually said that they wouldn't have taken disciplinary action against Mrs. Higgs if she had just stated her beliefs on her Facebook page. So if those beliefs that we looked at, if she just stated that these are my beliefs, or she'd stated, I don't believe in same-sex marriage, or I don't believe that somebody can change their biological sex, then the school said that they wouldn't have taken disciplinary action against her. But surely one could say that the reader could imply from that she was homophobic or transphobic. So it's a fine line, really, and it's quite a creative, I think, quite creative finding by the Employment Tribunal to get round this by saying she wasn't dismissed because of her beliefs, which are protected. She was dismissed because the reader could have reasonably formed the opinion that she held unacceptable views, i.e. transphobia or homophobia. So, I say, quite creative arguments in the tribunal, and I think, well, let's wait. I mean, she's obviously going to appeal, so we'll see what comes of that. So moving then on to the area of, sorry, I should have clicked on there, of sex discrimination. It's the case of Lee and Splunk. It's an interesting case. The facts of the case are that the fast-growing data analytics firm Splunk was founded in 2003 in Silicon Valley. Nadine Lee began working for the company in London as a regional sales manager in 2013. She became global account manager a year later, and by 2018, she was earning approximately £700,000 per year, comprising £95,000 basic salary and the rest in performance bonuses and commission. Lee was praised in 2017 for landing huge deals with 2 clients. Splunk's CEO at the time wrote, "Here is to the biggest deal of the quarter, masterful job from building the campaign to maturing and closing the deal. It took a village to win the client trust, and we are now on a safe path to adoption and success with one of the largest banks in the world. So proud of your game and accomplishment, Nadine Lee and team, respect." So in 2018, in the March, she's given her exceptional performance. She's granted 6 months period of unpaid leave to recharge her batteries. It was described by Splunk as a goodwill gesture, and it was made clear that she would resume her role as global account manager on her return to work. During her leave then, Lee's role was filled by somebody called Stephen Gracie, who had previously worked with 2 other colleagues in the business, a senior HR business partner, Julie Ward, and a UK area vice president, Alan Banks. Gracie headhunts somebody else called Dusinch, who he worked with previously and had known for a few years. So By then, the later part of the leave period, Lee became aware that the long-term 2 clients she'd previously dealt with had been reassigned to DISCRIMINATION, who she later discovered was actually being paid more than her. And despite her sales successes, she also discovered that she hadn't been nominated for the Sales Manager of the Year award. And in the previous 5 years, the highest attaining regional managers got put forward for these awards. She was the highest attainer in the previous year, and she wasn't nominated for the award. The tribunal was very critical of communications between the Splunk managers. In particular, following advice from the HR Business Partner Ward, Gracie emailed the claimant, copying in Banks, the other colleague, to say they wanted to discuss the allocation of accounts with her on her return. She replied saying, "Looking forward to meeting you and hitting the ground running. I appreciate you managing my account. I would like to discuss how the top sales manager award was decided. Thank you." Banks immediately replied to Gracie and Ward saying, "The game begins." And Gracie emailed back and said, "Yes, it does." Ward responded by beginning another email. And remember, she's the HR business partner. And she said, "I agree. I think the game begins. Suggest you just have 2 short bullet points and close it down, as we are not going to change, and provide her with the award. However, just a quick for your information, I think she may start to fight the account change and this award, etc. So we should put nothing in writing in an email with her name in it, as she can easily request that information via a subject access request, unless it is work related, etc., or specific confirmation or feedback which is going to her in any case." In the judgment, the judge states, we note at this point our concern regarding this email. Ms. Ward was suggesting that when managers communicated about the claims in the future, they shouldn't put her name on it if it was confidential, because it was in recognition that they could then, or she could get this email if she made a subsequent subject access request under the Data Protection Act or GDPR. Whether intended or not, this might well have the effect of hiding certain documents from disclosure in any litigation. The only reason the email emerged was because Mr. Banks responded to it using the claimant's name. We do not know if there are other emails which still remain unfound. The claimant raised a grievance, complaining about the removal of her 2 accounts, and also the failure to nominate her or provide her with the award. She also queried her pay against DISCRIMINATION's pay. Lee said a high-performing ethnic female was being pushed aside for the old boys network, and after appealing the outcome of the grievance, Lee resigned in August 2018. She then pursued a number of claims. So she pursued constructive unfair dismissal, saying that she had resigned because the employer had undermined the trust and confidence in the employment relationship and how it had treated her. She also made a claim for direct sex or race discrimination on the basis that her accounts were reallocated because of her sex. Thirdly, she said she was victimised, treated less favourably, further to her making allegation of discrimination. And then fourthly, she claimed equal pay against DISCRIMINATION because he conducted a similar job or the same job as her and he was being paid more than her. So what do we think the tribunal decided? Well, they upheld all the claims. They found that she had been constructively unfairly dismissed. They said that she had been treated less favourably because of her sex and or race by reassigning her accounts. and they said that she had been victimised by not being put forward for the manager's award, and they said that was because she had made an allegation of discrimination. The only thing they didn't hold in her favour was that she didn't receive the award because of her sex, but they held that that was an act of victimisation in any case. The judge said the claimant was a top performer, if not the top performer, in the division for many years. Removing and reallocating the accounts without the claimant's consent was a detriment. These were high value accounts on which she had built relationships. And she had received humiliating and hurtful comments as well. A remedy hearing will be scheduled, and no doubt the compensation is going to be considerable. So it's a big loss for the employer in this case. A point to note for us really is about the emails, in particular, that any employee or any individual can make a data subject access request under the GDPR to access their email or emails that refer to them. And it doesn't have to just be by reference to their name. If there is material within that email which identifies them, then that should also be disclosed under a data subject access request. So just something to bear in mind. But I wouldn't be suggesting that you do anything like the HRBP had suggested in that case. I'm sure you wouldn't. Moving on then to the area of discrimination relating to pregnancy and maternity. This is the case of Larkin against Liz Earle Beauty Company. The facts of the case are that Mrs. Larkin was a marketing manager within the firm's digital team. She told her employer she was pregnant in January 2018. At around the same time, the company employed a digital strategist and consultant, Miss S, in response to a growing need for online sales. Mrs. Larkin met with Miss S in February 2018 to discuss how Mrs. Larkin was going to be heavily involved in the new initiative. So Mrs. Larkin left that meeting feeling very positive about her future, and you know, the future was bright for her really in terms of her career progression and her work. Also in February, Mrs. Larkin received a positive appraisal, which indicated that she was exceeding in all areas. Later that month, the claimant's line manager told Miss S that Mrs. Larkin was pregnant. And from that time, Mrs. Larkin said that Miss S lost interest in her and had no further meetings with her about the work or about her progression within the company. Mrs. Larkin's line manager actually handed in her notice in March 2018, but was told by Miss S not to tell her staff at that point that she was leaving. Miss S then devised a new structure for the digital team in March, and the job that the claimant was doing would be made redundant further to this, along with 3 other roles. The tasks she had been carrying out were to be redistributed to the other roles, or to other roles. Mrs. Larkin and the other affected employees were not told about the plans until a couple of months later. Mrs. Larkin was subsequently dismissed by reason of redundancy. So what did she do? She pursued claims of discrimination on the ground of pregnancy and or maternity, and she also brought claim for unfair dismissal. During the hearing, various evidence was presented, including that the employees who were affected by the restructure were told about the company's plans in early May, but Mrs. Larkin wasn't told until later on in May, at the end of May. And around the 17th of May, Miss S had recruited somebody to be appointed in the role of Mrs. Larkin's line manager. Now, Mrs. Larkin said that this was done before placing her at risk of redundancy. So she wasn't then offered the opportunity to apply for her line manager's role. And she said that she had the skills and the experience to do that role, and she should have been offered at least that opportunity to apply. The respondent said that they had considered her potentially for the role, but she didn't have the skills or experience. So what do we think the tribunal decided? Well, they decided that it was possible that Miss S's decision in making Mrs. Larkin redundant was influenced by the claimant's pregnancy and her imminent maternity leave in July 2018. And they decided that actually they sided with Mrs. Larkin, and they said, we do believe that she had the experience and the skills to carry out the line manager's role, or at least be given the opportunity to apply for that role. And they thought it very suspicious that Mrs. Larkin wasn't told about her being at risk of redundancy until after the appointment for the line manager role had been made. They relied also on a conversation that Miss S had with Mrs. Larkin at one of the redundancy meetings. And there was a suggestion, they said, because of that conversation, that Miss S thought that the claimant would be better off enjoying her maternity leave rather than thinking about and worrying about returning to work and pursuing her career. So all in all, the tribunal found that the redundancy was both unfair and was discriminatory on the grounds of pregnancy and maternity. And she was awarded £17,303.20 in compensation for that. In respect then of the next case I'm just going to touch upon, it's the case of Taylor and Jaguar Land Rover Limited. The facts of this case are that Ms. Taylor worked for Jaguar as an engineer. In 2017, she told managers that she was transitioning from male to female. Further to this, she suffered harassment and discrimination after she started to attend work in female clothing. The tribunal found numerous instances of mistreatment, including colleagues openly ridiculing her appearance, referring to her as it, and asking her whether she was going to have her bits chopped off. She eventually resigned, and she brought claims for discrimination on the grounds of gender reassignment, and she also brought a claim for constructive unfair dismissal. Jaguar Land Rover initially attempted to defend this case on the basis that Ms. Taylor did not have the protected characteristic of gender reassignment because she had not yet undergone any medical treatment or medical transitioning treatment. The definition of gender reassignment in the Equality Act is as detailed on the slide. So it's if the person is undergoing or has undergone a process for the purposes of reassigning the person's sex by changing the physiological or the attributes of sex. Jaguar tried to argue that Miss Taylor was not protected because she was calling herself or referring to herself as non-binary or gender fluid. The Employment Tribunal held, quite rightly, that because she was on a journey of transition, she was covered, albeit at that time she hadn't undergone any kind of medical process. Just touching on vicarious liability, and in particular the Morrison's case, I have referred to this in previous huddles, And you may recall that it involved an employee of Morrison's who had access in their role to employee data. And what they did was they leaked that data, and it was thousands of employees' data. So obviously it was a clear breach of GDPR, data protection legislation. He made a copy of the payroll file and he sold it, in effect, virtually. So he was taken through a disciplinary process, he was dismissed and is now in prison. In a group litigation process, 9,000 Morrison's employees and former employees brought a claim for compensation against Morrison's for breach of the data protection legislation. And in the High Court and the Court of Appeal, Morrison's were held to be vicariously liable for the employees' actions, and therefore due to pay all these employees compensation. That was a really frightening judgment for many employers, because they thought, well, how unfair is this? You know, we've done all we can to protect this data. How can we be held to be responsible for the illegal actions of an employee? The Supreme Court has now made their decision on the case. It was appealed. And thankfully it sides with employers on this, and it has held that Morrison's is not vicariously liable for the particular employee's actions. They said in the judgment that it was clearly, you know, a vendetta, a personal vendetta against Morrison's that this employee was doing. It basically said that wrongful conduct, this wrongful conduct was closely connected with the employment, but it held that it was being done outside the course of employment, outside of his role. It was not so closely connected with his work and his role to be able to find that Morrison's was vicariously liable for it. Saying that, there is a sting in the tail of in the decision. So the Supreme Court said an employer can be held vicariously liable in situations where an employee commits a data breach in the course of their employment, in the course of their role, in the course of their everyday work. So just bear that in mind. But thankfully it's gone in the employer's favour, that one. Just then quickly on the up-to-date legislative developments, most of which came in, or these came in April of this year. The Vento bans have been increased. So these are the bans that reflect the damages awarded to successful claimants for discrimination. The bans are 3, as detailed on the slide, and the compensation for injury to feelings will fall into these bans depending on the gravity of the discrimination, whether the discrimination consists of a one-off act or a course of conduct over a long period of time. And depending on the impact of the discrimination on the particular claimant. So obviously, if we are considering a long period of discrimination that has had a substantial impact on, for example, the mental health of a claimant, then you would be looking at upper band injury to feelings ranging from £27,000 to £45,000. Obviously, in addition to this injury to feelings awards, employees or claimants could be awarded loss of earnings that flow from the discriminatory acts. And hence the reason why discrimination awards can be significantly high. So they've been updated. Also worthy of note, this one, particulars of employment required to be given to employees have been updated and extended. So from April, employers have an obligation to provide particulars of employment now to workers as well as employees. And they also are obliged to provide particulars of employment to employees and workers in a single document on or before employment commences, which is obviously a change. Just to note there that there are some exceptions to that. So the exceptions are relating to pensions, collective agreements, and non-compulsory training entitlements. And the employer is required to provide those details no later than 2 months after the commencement of employment. Only particulars relating to incapacity and sick pay, paid leave, pensions, and any non-compulsory training entitlement provided by the employer may be contained in another document that is referred to in the main document. So it has to be an accessible document and, as I say, referred to. The statement is required to contain now the following additional particulars. They include the days of the week that the employee or worker is required to work, and whether the days and working hours may be variable, and how any variation will be determined, example, a rota. But the days of the week still need to be specified. So it might be stated, employees required to work X number of hours per week from Monday to Sunday in accordance with a rota. So the days of the week still need to be specified. Also, any paid leave to which the worker is entitled. So that refers to maternity leave, paternity leave, adoption leave, or the family-friendly leave. There now needs to be a clause in the particulars in the contract of employment which states that the employee is entitled to this paid leave. And it might just be a reference to the statutory payment that the employee receives. If obviously the employer enhances that payment, then that needs to go in. So that's quite a big change because we didn't have that in before. Also, any probationary period needs to go into the particulars. So if employers had been including that in another document, it now needs to go into the particulars, and it needs to include any conditions of the probationary period and also its duration. Also, the particulars need to include any training entitlement provided by the employer, including whether any part of that training is mandatory and any other mandatory training which the employer will not pay for. So it's paid for training as well as non-paid for training, and it's mandatory, compulsory, as well as optional. So that needs to go in now in the particulars. There's no longer a minimum 1 month service requirement in order that a worker is entitled to receive a written statement of particulars, which I've said. So these become day one rights now, where the particulars must be provided. And then just one last point, the extension of the IR35 requirements has been postponed. So it was due to come in this April. There was a lot of work that a lot of organisations did to be ready for this, and it related to personal service companies. So where organisations were contracting with personal service companies on a self-employed basis, there were new rules that apply, tax rules that apply, where the personal service companies have to come on payroll in effect. And an assessment needs to be made as to whether or not the personal service companies, in ignoring the entity, the person working in the personal service company, could be deemed to be a worker. and if they did, then they need, and that personal service kind of needs to come onto payroll. So that has been postponed until next year now. And that's it. So if there are any questions, then obviously let us know, and you can post them in the chat box.
Brilliant. Keeley, thank you so much. You make it so interesting as ever. I know it's different when we're not all together to be able to like kind of have the conversation at the same time. So, but I hope everybody enjoyed it. Has anybody got any questions for Keeley before we close the meeting?
No.
No? No?
That's great.
Well, if you do think of anything, then feel free to contact Keeley directly, or obviously contact myself, and I can put you guys together. But thanks, Keeley. It was wonderful. If anybody's got any suggestions of future topics, obviously we'll always do employment law sessions, and I know we've done a lot of different kind of COVID topics. But if anybody's got any suggestions of topics they want us to cover, then please feel free just to email me or pick up the phone and speak to me, and I can organise specific guest speakers. But is it too early to say have a wonderful Christmas if I don't everybody?
Merry Christmas. Never too early.
I did contemplate bringing my mince pie to as you suggested, Keeley, but great. So yeah, thank you very much, everybody. I'll send the video out and the slides hopefully within the next few days. I know it always takes me longer than I anticipate, so bear with me. But yeah, thank you very much, and we'll see you all soon.